Scorpio.
Walks like a hostile intelligence service and talks like a hostile intelligence service.
Good evening, people. Welcome to the game room here at the Shrimp Castle. Julian Assange update we got going on today. Let me turn this up a bit. And a lot of transpired days-wise since our last update, which was on Friday, I believe, Friday or Saturday. We got day 17, which was today, and that is the 30th of September. But let's go back to day 15, which was the 28th. That was Monday. Assange, Julian Assange, the famous, the infamous, would face solitary confinement and extreme restrictions if sent to the United States. The final week of the testimony portion of Julian Assange's extradition hearing began with Yancey Ellis, a former judge advocate in the U.S. Marines who practices in Alexandria, Virginia. Ellis has defended many clients who would be held at the Alexandria Detention Center, ADC, where Assange would be detained before trial if he were to be extradited. At issue is whether extraditing Assange be cruel or oppressive, and whether he would be subject to torture or to inhuman or degrading treatment or punishment. Ellis believes it would most likely be that Assange would be held in the X Block at ADC, the housing unit for administrative segregation, or ADSEG, which he said constitutes solitary confinement. Assange would be held there due to a combination of his notoriety and his mental health condition, Ellis said. Speaking from his experience visiting clients at the ADC, Ellis said that inmates on the X Block live in 50-foot square cells for 22 to 23 hours a day, similar to my friend Pepsi Watson and colleague. If you want to check out my interview with Pepsi Watson, you can go on my YouTube channel. They have no access to therapeutic or other programs and no interaction with other prisoners. In his witness statement, Ellis writes that there is no outside recreational or exercise area at the Alexandria jail, and I do not recall there being any windows in the ADSEG unit. The prosecution has submitted a witness statement from Assistant U.S. Attorney Gordon Kromberg, who wrote that inmates in ADSEG at the ADC can access prison programs and can speak through doors or windows to communicate from cell to cell. Ellis writes that several assertions made by Mr. Kromberg are correct or incomplete, and has tried to communicate with the prisoner through cell doors, and you have to scream to be heard. The whole point of this unit is to keep you away from other inmates, he said. These are all the basic minimum physical conditions of the X Block, Ellis said, and special administrative measures, or SAMs, S-A-M-S, impose further restrictions on outside communications on top of that. Ellis also spoke about mental and physical health care at the facility. The ADC doesn't employ a doctor, but contracts with part-time psychiatrists. Ellis said that many of his clients needing their medication to be modified would go several weeks between psychiatric visits. Ellis writes that inmates at risk of self-harm are placed in a suicide prevention suit that immobilizes the arms away from the body, removing shoestrings and sheets, etc., presumably to prevent suicide. The extent of mental health care is that a social worker or counselor comes around to check on you every once in a while to ensure basic functioning, he said. Joel Sickler is our next on the defense from Monday. A prison advocate for more than 40 years who founded the Justice Advocacy Group in Virginia. Sickler has been to Alexandria Detention Center dozens of times and has many clients detained there, and he testified about his experiences there. He also discussed his knowledge of the ADX Florence, the infamous ADX Florence, which houses El Chapo, and Ted Kaczynski in Colorado, the Supermax federal prison where Assange is likely to be imprisoned post-trial if extradited and convicted. Sickler testified that he believes that pre-trial in the ADC, Assange will be housed in ADSEG on the X block. He agreed with Ellis's characterization of the cells there as about the size of a parking space. Sickler also noted that AUSA Kronberg claims that inmates in AGSEG at ADC can communicate with each other, but in practice, that's ridiculous. He absolutely won't have communication with other inmates, he said. Inmates on this unit have very limited access to the outside world, Sickler said. You're twiddling your thumbs. You'll have access to reading material. Your whole world is the four corners of that room. He also testified about the lack of health care at the Alexandria facility. Mr. Assange should expect to receive only the most limited medical services at the ADC. Any suggestion to this court that he will be fully evaluated and assessed for medical or mental health conditions is misleading. Furthermore, Sickler said that legal opportunities to challenge your status under SAMs are incredibly small. It's a well-known fact here that even the most minor administrative appeals by inmates are denied. I've probably filed 1,000 or more appeals, winning a dozen at most. The chances of appealing SAMs are remote to nil. The prosecution then spent the afternoon taking Sickler through Bureau of Prison Policies and claims about their staffing, healthcare provisions, and the ADX's level of housing through which inmates can work to reduce their restrictions and ultimately get off of SAMs. But time and again, Sickler would testify that what the BOP claims on paper is far different than what happens in practice. He said that the Marshall Project's reports on the ADX Florence are spot on. Prosecutor Claire Dobbin cited the case of Cunningham versus BOP, in which inmates sued the Bureau of Prisons and ultimately agreed to a settlement which led to mentally ill inmates being moved out of the ADX. Sickler addressed that case in his own statement, noting that just 3 years after that settlement was upheld, that same court would find that the healthcare in ADX failed to meet basic standards of care for inmates. Dobbin also cited the fact that Umar Farouk Abdul Muttalib, a convicted terrorist at the ADX, has said he could see family members while detained there. But as the New York Times reported in 2017, Abdul Muttalib sued the Justice Department, arguing that prison officials are violating his rights by holding him in solitary confinement, restricting his communication with relatives, and force-feeding him when he goes on hunger strike to protest. Responding again to Dobbin's reading through BOP policies as to care they provide, Sickler said, "What I see ongoing in practice is entirely different." That was from the 15th day of the trial, the 28th of September 2020. Let's go to day 16. John Rees, a don't extradite Assange advocate. Former warden says that Assange would get desolate and degrading special administrative measures. That's the vocab word of the day, folks. Special administrative measures. Even though it's 3 words, it's part of the vocabulary phrase, phraseology for the quiz that will be coming. Just kidding. Former prison warden Maureen Baird, who presided over the Metropolitan Correctional Center in New York and who worked in the U.S. prison system for more than 20 years, testified today about the special administrative measures that she believes Julian Assange would be subjected to if he were extradited to the United States. At issue are Assange's potential pre-trial and post-trial prison conditions, because the UK cannot extradite if doing so would be unjust or oppressive, or would subject the defendant to inhumane or degrading treatment. What are special administrative measures, you may ask? Special administrative measures are a layer of extreme gagging restrictions on a prisoner that render them in effect incommunicado. SAMs are an additional layer on top of an individual prison's conditions, such as solitary confinement. SAMs are only imposed by the U.S. Attorney General after a determination is made with the input of an intelligence agency. Baird testified that in Assange's case, it's likely the CIA and Department of Justice would be involved in the decision to place him under SAMs, and the direction would come from Attorney General Bill Barr. Baird testified about the inmates she oversaw who were under SAMs. Inmates were in solitary confinement technically for 24 hours per day. Again, this is the warden, former warden. There's absolutely no communication by any means with other inmates. The only form of human interaction they encountered was when correctional officers opened the viewing slot during their inspection rounds of the unit, when institution staff walked the unit during their required weekly rounds, or when meals were delivered through the secure meal slot in the door. Inmates are allowed 30 minutes of phone time per month, she testified, and all calls are monitored by an FBI agent and must be scheduled 2 weeks in advance. The effect of SAMs. Baird testified that to call conditions under SAMs, SAMS, unduly harsh is an understatement, and that they afford no real avenue to challenge or appeal. In her statement to the court, Baird agreed with Joel Sickler's description of conditions for SAMS inmates as desolate and degrading, as well as Lindsay Lewis's description of the devastating effects caused by isolation. The conditions are so bad, she wrote, that she can't believe they still exist. I am uncertain how the BOP has been able to continue with these types of isolation units, given all the studies, reports, and findings of the horrific physical and psychological effects they have on inmates. SAMs at the Colorado Supermax. The defense and prosecution agree that if extradited, Assange would be held pre-trial at the Alexandria Detention Center in Virginia. The defense argues that post-trial, Assange would be held in ADX Florence in Colorado, the highest security prison in the United States, which its former warden has called a clean version of hell. A former prison designator herself, Baird testified today that she believes it's very likely that if Assange is placed under SAMS, he would be detained at the ADX in the segregated housing unit. As someone who spent the majority of her adult life working for the BOP and as a former designator who decided where inmates would serve their sentences, absent a medical requirement or a protected witness security case, I am not familiar with any alternative long-term options aside from the ADX for offenders under SAMS. ADX for offenders under SAMS. That's what I should say, SAMs. While the prosecution claims that they don't know where Assange would be imprisoned if convicted, they've argued at length in court and by way of cross-examination that the ADX is a humane facility. Similarly, while the prosecution claims they don't know whether Assange would be subject to SAMS, they have argued that SAMS are applied for good reason, that inmates can remove SAMS restrictions, and that SAMS inmates can sometimes reduce restrictions to be able to speak to other prisoners. Baird's testimony directly contradicts many of the assertions made by the prosecution's chief witness, Assistant U.S. Attorney Gordon Kromberg, in his affidavits to the court. Kromberg listed many of the social and therapeutic programs offered at the ADX in Colorado. Baird replied, "For anyone to suggest that an inmate assigned under SAMS would be able to participate in group counseling is baffling to me. The main premise of assigning SAMS is to restrict a person's communication, and the only way to accomplish this is through isolation." Kromberg also suggested that inmates under SAMS could challenge their conditions through an administrative remedy process. As Baird testified today, a prison warden has no ability to modify how SAMs are applied, and they are applied equally to prisoners across the board. During my 28 years with the BOP, there were times that I was responsible for responding to administrative remedies. One moment. Agreed, Deborah. Let me bring this down a little bit. Actually, let me do this. Here, I gotta move closer, don't I? Okay, I needed a drink, people. So, I don't even know if you guys need to see me or not. I don't think you do. You can see my eyes, right? Okay, day 16, September 29th. During my 28 years with the BOP, again, this is Baird, the former prison warden, there were times that I was responsible for responding to administrative remedies. With certainty, I declare for purpose of challenging SAMs, it would be a futile process. The BOP exercises no control and jurisdiction over SAMs imposed by the Attorney General. Wardens are bound to abide by the SAMs imposed on an inmate. During my term as warden at MCC New York, I've never seen an inmate have SAMs removed, only extended. That sounds like something a prison would do. Lindsay Lewis. Assange will almost certainly be placed under SAMs. The defense then called Lindsay Lewis a U.S. attorney who has represented Abu Hamza, whose legal name is Mostafa Kamel Mostafa, a convicted terrorist who is detained at the ADX Florence in Colorado. Central to her testimony, let's get a picture of her so you guys can see her. That would fix our problem here. So, testifying for the defense is this lovely attorney, Miss Lindsay Lewis. She has represented a convicted terrorist, as mentioned, at ADX Florence. Central to her testimony was the fact that when Hamza faced extradition from the United Kingdom to the United States, the U.S. gave assurances to both English courts and the European Court of Human Rights that he wouldn't be held at ADX Florence without a medical exam to determine if he could survive daily activities. She said Assange would almost certainly be placed under special administrative measures if extradited to the United States. The UK courts operated, Lewis said, under the assumption it was impossible that Hamza, a double amputee with diabetes and blindness in one eye, would pass such a test and therefore would not be detained at the ADX. Hamza has been imprisoned under SAMs and in solitary confinement for the last 8 years, and has been imprisoned at the ADX Florence since 2015. Lewis explained in her witness statement that SAMs limit Hamza's contacts not just with the outside world, but also with his family, other inmates, and even his attorneys. She says the restrictions SAMs impose on her as his lawyer limit her own ability to describe his conditions to the court. The restrictions are so absurd, she said, that Hamza was written up for violating SAMs when he improperly tried to convey in a letter to one of his sons his love to his 1-year-old grandson, because the grandson is not an approved contact for him to speak to. Lewis also testified about the inability to redress grievances under SAMs. The prosecution's witness, Gordon Cromberg, suggested that SAMs could be lifted if appealed, and sometimes aren't renewed after a year. Lewis testified, as Baird did earlier, that inmates must exhaust the long, drawn-out administrative remedy process before they can sue the Bureau of Prisons in court to try to get the SAMs removed. Lewis said she'd never heard of any case in which an inmate successfully got SAMs removed through the administrative remedy process. Anonymous witnesses to testify on embassy spying. The judge granted anonymity to 2 witnesses from UC Global. And what's the judge's name? Her name is Vanessa Baraitser, Baraitser, UC Global, who will testify about the company spying on Julian Assange in the Ecuadorian embassy in London. Remember, UC Global was the Spanish security company. El País reports that, El País, I'm reading this with my English voice. El País. El País reports that UC Global director David Morales traveled to Las Vegas, where he secured a contract with a company working for top Trump financier Sheldon Adelson to spy on Assange and provide recordings to the CIA. The witness statements will be read aloud in court later this week. Again, the anonymous witness statements, 2 of them from UC Global, the Spanish company who won the contract with the CIA to spy on Assange. And we heard about that today in court, it looks like. Let's go to today, the 30th, day 17 of the Assange trial, September 2020, the 30th day of this month. And there is UC Global Director David Morales. The defense read several witness statements aloud in court today. That was today, folks, including 2 statements from anonymous former employees of UC Global, the Spanish security company led by David Morales, which spied on Julian Assange in the Ecuadorian embassy in London. The witness statements testified to the particular zeal Morales had in recording conversations between Assange and his lawyers, as well as his contract with an American company to report the recordings back to American intelligence officials. So lots of external links for Spanish security company spies on Julian Assange's meetings with lawyers. 3 protected witnesses accuse Spanish ex-Marine of spying on Julian Assange. U.S. demands hinder Spanish probe into alleged CIA ties to security firm that spied on Assange. New court files expose Sheldon Adelson's security team in the U.S. spy operation against Julian Assange. Because these statements were particularly long, see excerpts in this separate post. So that actually, I'll probably do that in a separate broadcast, just because they're pretty long. As she said, let's focus on the main points for today. Patrick Cockburn WikiLeaks showed us the realities of war. Patrick Cockburn is an investigative reporter for The Independent. See his article, Julian Assange in Limbo, in the London Review of Books from earlier this year. An excerpt. I was in Kabul when I first heard about the WikiLeaks revelations, which confirmed much of what I and others had suspected. The trove was immense. Some 251,287 diplomatic cables, more than 400,000 classified army reports from the Iraq War, and 90,000 from the war in Afghanistan. Rereading these documents now, I'm struck again by the constipated military bureaucratic prose, with its sinister dehumanizing acronyms. Killing people is referred to as an escalation of force, something that happened frequently at U.S. military checkpoints when nervous U.S. soldiers directed Iraqi drivers to stop or go with complex hand signals that nobody understood. What this could mean for Iraqis is illustrated by brief military reports, such as the one headed Escalation of Force by 38NE Fallujah. One civilian killed in action, 4 civilians wounded in action. Decoded. It describes the moment when a woman in a car was killed and her husband and 3 daughters wounded at a checkpoint on the outskirts of Fallujah, 40 miles west of Baghdad. The U.S. Marine on duty opened fire because he was unable to determine the occupants of the vehicle due to the reflection of the sun coming off the windshield. Another report marks the moment when U.S. soldiers shot dead a man who was creeping up behind their sniper position, only to learn later that he was their own unit's interpreter. These reports are the small change of war, but collectively they convey its reality far better than even the most well-informed journalistic accounts. Those 2 shootings were 1,000 times repeated, though the reports were rare in admitting that the victims were civilians. More usually, the dead were automatically identified as terrorists caught in the act, regardless of evidence to the contrary. The WikiLeaks documents expose the way the U.S., as the world's sole superpower, really conducted its wars, something that the military and political establishments saw as a blow to their credibility and legitimacy. There were some devastating revelations, the helicopter video among them, but many of the secrets uncovered were not particularly significant or indeed very secret. In my view, they do not themselves explain the degree of reaction that the WikiLeaks revelations provoked from the U.S. government and its allies. I consider this to have been the response to a perceived assault on their monopoly control of sensitive state information, which they saw as an essential prop to their authority. Making such information public as Assange and WikiLeaks had done weaponized freedom of expression. If disclosures of this kind went unpunished and became the norm, it would radically shift the balance of power between government and society, and especially the media, in favor of the latter. WikiLeaks did what all journalists would do, or should do, which is to make important information available for the public, enabling people to make evidence-based judgments about the world around them, and in particular, about the actions of their governments and of those actions more than any other of those that reveal the gravest of state crimes. In my view, steps taken against Assange for publishing information of such great importance betrays the true motivation behind the unprecedented steps being taken to criminalize his actions. In 2010, WikiLeaks won a great victory for freedom of expression and against state secrecy, and the U.S. government is now making every effort to reverse it. And again, that was from Patrick Cockburn investigative reporter for The Independent. This next excerpt is from Ian Cobain, an investigative journalist who was with The Guardian in 2010 and 2011. There is always the understanding, one that is so clear that it needs not be spoken, that anyone who has knowledge of state crimes and who comes forward to corroborate allegations about those crimes may face prosecution. Evidence that would support such allegations is extraordinarily difficult to obtain from within governments with disciplined intelligence agencies, and civil services, and where the penalties for unauthorized disclosure can include intrusion into family life, prosecution and imprisonment, loss of livelihood, and loss of pension rights. Cobain reported to British intelligence helping the CIA kidnap an entire family and render them to Libya, where they were tortured. Almost certainly, nothing of this case would have emerged into the public sphere were it not for the unique emergence of hundreds of documents relating to the Libyan security state. The documentary evidence emerged during a serendipitous moment in Tripoli during the 2011 Libyan revolution, when filing cabinets full of documents belonging to the Libyan security apparatus fell into the hands of NGO workers and journalists. Had the documents not emerged in the way in which they did, the British government would no doubt have continued to maintain that the UK does not participate in, solicit, encourage, or condone the use of torture for any purpose, a claim that is completely undermined by the documentary evidence now available in respect of this case. In the event, the government apologized to the couple and made a payment to the wife. A case brought by the family was settled out of court. Under these circumstances, it could be argued that media scrutiny is more important than ever, and that leaks and whistleblowers remain a vital means by which state crimes can be exposed. Again, that was a former Guardian investigative journalist whose name is Ian Cobain. This is from Guy Goodwin Gill, GGG. On 16 June 2016, I attended a meeting at the Ecuadorian Embassy in London to discuss the international legal aspects of the asylum accorded to Mr. Julian Assange. Those attending included the Foreign Minister of Ecuador, senior Ecuadorian officials, and members of Mr. Assange's legal team. Before entering the ground floor meeting room, I left my passport, phone, and tablet at the door, together with unlocked luggage. I was en route to give lectures in Italy. I naturally assumed that given the precautions taken before entry, such a legal conference would be secure and confidential. I was therefore somewhat shocked, to say the least, to learn in late 2019 that my name featured in papers lodged in connection with legal proceedings in Spain concerning the disclosure of confidential information, that the occasion of my visit and participation had been shared with various parties, and that my electronic equipment may have been copied and the contents also shared. Mr. Assange is not a citizen of the United States of America, and that most of the charges leveled against Mr. Assange are drawn from the U.S. Espionage Act. Espionage is not defined in international law. It is neither an international crime nor a serious crime of international concern, and it is commonly considered to be a purely political offense, which either would not be listed as an extradition offense or is one for which surrender would be refused. It is against this background and the political opinions involved, therefore, that the evidence of surveillance and the sharing of confidential, privileged information needs to be considered, and an assessment made of whether these factors indicate more clearly the political motivation, intent, and purpose of the extradition request, or otherwise indicate the likelihood of prejudice, punishment, detention, or other restrictions on liberty by reason of extraneous circumstances as described above. Next up is Stefania Morizzi, an Italian journalist who worked with WikiLeaks to report on Italian documents within the State Department cables. Assange and the war. On more than one occasion, Mr. Assange expressed to me his view that if WikiLeaks had existed before the US invaded Iraq and had published what it later published earlier, the collateral murder video with respect to Iraq, for example, the war might have been avoided or would have come to an end sooner. The fact is that what had been and what was being disseminated by the governments involved, in particular the United States of America, was largely false, and the true picture was not being allowed to be known. I myself was given access to 4,189 cables, which could be better assessed and understood with the assistance of a knowledgeable Italian partnership. I sat down with Mr. Assange and went through the cables as systematically as possible. I was given an encrypted USB stick, and once I returned to Italy, I was given the password that would then allow opening the file. Everything was done with the utmost responsibility and attention. I am aware of the password that David Lee and Luke Harding of The Guardian subsequently published in their book. It was not the same password I myself was given at the time. That was the first time I had ever worked in any publishing enterprise involving strict procedures of that kind. Even experienced international colleagues found the procedures burdensome, involving protections considerably beyond those which any of them were accustomed to exercising. Robert Boyle is a U.S. attorney and an expert on grand juries. His statement recounts relevant portions of Chelsea Manning's elocution statement made at her court-martial, and then discusses her imprisonment for refusing to testify to a secret grand jury. Secret grand jury, special grand jury, you know how those work. Manning explained that due to her position as an intelligence analyst, she had access to information about United States military activities in Iraq. Some of those activities contradicted the stated goals of U.S. policy. She told the court, "The United States military became obsessed with capturing and killing targets on lists and being suspicious and avoiding cooperation with our host nation partners and ignoring the second and third order effects of accomplishing short-term goals and missions. I believe that if the general public, especially the American public, had access to the information, this could spark a domestic debate on the role of the military and our foreign policy in general, as well as it related to Iraq and Afghanistan." A participant in an online chat pointed Manning to WikiLeaks' online submission system. Manning was somewhat familiar with WikiLeaks. In her view, the organization seemed to be dedicated to exposing illegal activities and corruption and had received numerous awards and recognition for its reporting activities. Regarding collateral murder, the collateral murder video, Manning told the court that she wanted the American public to know that not everyone in Iraq and Afghanistan were targets that needed to be neutralized, but rather people who were struggling to live in the pressure cooker environment of what we call asymmetric warfare. Although I stopped sending documents to WikiLeaks, no one associated with WikiLeaks pressured me into giving more information. The decisions I made to send documents and information to WikiLeaks were my own decisions, and I take full responsibility for my actions. Manning, subpoenaed, refuses to testify and is punished further. Manning filed a motion to quash the subpoena. Chelsea Manning argued that the subpoena was improper and that it was an effort by the government to punish her for the release of the information to WikiLeaks. Manning also pointed out that the government had available to it her exhaustive sworn statement before the military court that was given at the time of her guilty plea, and which truthfully set forth the full extent of her knowledge, including but not limited to her contacts with WikiLeaks. Manning asserted that compliance with the subpoena would also enable the government to set a perjury trap. Should there be inconsistencies, even minor inconsistencies between her court-martial testimony and grand jury testimony, she could be criminally charged with committing perjury. Manning was imprisoned for refusing to testify. Chelsea Manning was placed in solitary confinement despite the stated concerns regarding the effects of prolonged isolation that compounds the trauma I suffered from my previous time of confinement. Manning remained in isolation for 28 days, an experience that caused her extraordinary pain. He quotes her own statement. I understand that this grand jury is related to my disclosures of classified and unclassified information and records in 2010. I acted alone in these disclosures. The government is still preoccupied with punishing me, despite a court-martial, sentence, and presidential commutation nearly 2 years ago. Manning believed the U.S. government wanted information ahead of Assange's hearing. As Manning herself has stated, I suspect that the government is simply interested in previewing my potential testimony as a defense witness and attempting to undermine my testimony. This justifies my theory that participating in this investigation functions simply to abuse the justice system for political ends. Andy Worthington is up next. He is a United Kingdom-based activist and researcher who has studied the Guantanamo Bay prison for over a decade. He's made a couple statements, which we may go over in the future. I want to keep this broadcast succinct and cover all the big points. So, excuse me. In April 2011, Worthington wrote that WikiLeaks reveals a secret Guantanamo files, exposes detention policy as a construct of lies. In its latest release of classified U.S. documents, WikiLeaks is shining the light of truth on a notorious icon of the Bush administration's war on terror, the prison at Guantanamo Bay, Cuba, which opened on January 11, 2002, and remains open under President Obama, despite his promise to close the much-criticized facility within a year of taking office. In thousands of pages of documents dating from 2002 to 2008, and never seen before by members of the public or the media, the cases of the majority of the prisoners held at Guantanamo, 765 out of 779 in total, are described in detail in memoranda from JTF Gitmo, the Joint Task Force at Guantanamo Bay, to U.S. Southern Command in Miami, Florida, known as Detainee Assessment Briefs, or DABS, D-A-B-S. These memoranda, which contain GTMO recommendations about whether the prisoners in question should continue to be held or should be released, that is, transferred to their home governments or to other governments, contain a wealth of important and previously undisclosed information, including health assessments, for example, and in the cases of the majority of the 172 prisoners who are still held, photos, mostly for the first time ever. Crucially, the files also contained detailed explanations of the supposed intelligence used to justify the prisoner's detention. For many readers, these will be the most fascinating sections of the documents, as they seem to offer an extraordinary insight into the workings of U.S. intelligence. But although many of the documents appear to promise proof of prisoners' association with Al Qaeda or other terrorist organizations, extreme caution is required. The documents draw on the testimony of witnesses, in most cases, the prisoners' fellow prisoners, whose words are unreliable, either because they were subjected to torture or other forms of coercion, sometimes not in Guantanamo, but in secret prisons run by the CIA, or because they provided false statements to secure better treatment in Guantanamo. Uncomfortable facts like these are not revealed in the deliberations of the Joint Task Force, but they are crucial to understanding why what can appear to be a collection of documents confirming the government's scaremongering rhetoric about Guantanamo, the same rhetoric that has paralyzed President Obama and revived the politics of fear in Congress, is actually the opposite. The anatomy of a colossal crime perpetuated by the U.S. government on 779 prisoners who, for the most part, are not and never have been the terrorists the governments would like us to believe they are. Next up, Jamil Jaffer. Assange indictment gravely threatens press freedom. Jamil Jaffer is an executive director of the Knight First Amendment Institute at Columbia University. In 2019, he joined Jeremy Scahill's podcast called Prosecuting Julian Assange for Espionage as a Coup Attempt Against the First Amendment. That's a great podcast name. Earlier this year, Mr. Jaffer joined the Courage Foundation's panel at the National Press Club in Washington, D.C. to discuss the impact of the Assange indictment on press freedom, on the indictment and Trump's view toward journalism. The indictment of Mr. Assange poses a grave threat to press freedom in the United States. This case is the first in which the U.S. government has relied on the 1917 Espionage Act as the basis for the prosecution of a publisher. The indictment focuses almost entirely on the kinds of activities that national security journalists engage in routinely and as a necessary part of their work cultivating sources, communicating with them confidentially, soliciting information from them, protecting their identities from disclosure, and publishing classified information. The indictment's implicit but unmistakable claim is that activities integral to national security journalism are unprotected by the U.S. Constitution and even criminal. In my view, the indictment of Mr. Assange was intended to deter journalism that is vital to American democracy, and the successful prosecution of Mr. Assange on the basis of the activities described in the indictment would certainly have that effect. On the wide breadth of the Espionage Act. These provisions are extremely broad, as many others have observed, and they criminalize a wide range of activities that may bear little resemblance to classic espionage. The Act exposes leakers to severe penalties without regard to whether they acted with the intent to harm the security of the United States. As it has been construed by the courts, the Act is indifferent to the defendant's motives and indifferent to whether the harms caused by disclosure were outweighed by the value of the information to the public. By its terms, the Act also provides for the imposition of these same severe penalties on subsequent publishers, i.e., not just on leakers, and not just on the news organizations that first published the leaks, but on anyone who later shares the leaked information through any channel, formal or informal. He then speaks on the importance of publishing government secrets. At least in the United States, informed public deliberation about matters relating to war and security would be impossible if the press did not publish classified information. There are structural reasons why unauthorized disclosures or classified information are so vital to the public's ability to understand, evaluate, and influence government policy relating to war and security. If the press did not publish classified information without authorization, public debate about war and security would take place in an information environment controlled almost entirely by executive branch officials. On using the Espionage Act against a publisher, the government's use of the Espionage Act against government insiders who supply classified information to the press poses a serious threat to the ability of the press to inform the public about matters relating to war and security. The government's indictment of a publisher under the Act, however, crosses a new legal frontier. The conviction of Mr. Assange under the Act for the activities described in the indictment would have a significant chilling effect on journalism that is vital to the proper functioning of American democracy. Some government officials have argued that the indictment should not be understood as a threat to press freedom because Mr. Assange is not a journalist, or because WikiLeaks is not a member of the press. This argument misses the point. The indictment is mainly a description of Mr. Assange engaging in core journalistic activities. And that was the update for day 17 of the Julian Assange trial, 30 September 2020. I believe one more insert was posted on the live blog. So again, that was today. Let's just check this out. So the defense read several witness statements allowed in court today, including 2 statements from anonymous former employees of UC Global, the Spanish security company led by David Morales, which spied on Julian Assange in the Ecuadorian embassy in London. The witness statements testified to the particular zeal Morales had in recording conversations between Assange and his lawyers, as well as his contract with an American company to report the recordings back to American intelligence officials. Anonymous witness 1. So again, these are this guy is from UC Global in España, in Spain. UC Global secures contract with Trump financier Sheldon Adelson around July 2016, by which time UC Global was already providing security services under a contract with the government of Ecuador in London. David Morales traveled to a security sector trade fair in Las Vegas, which I wished to accompany him on, but he insisted he had to travel alone. On this trip, Mr. Morales showcased the company UC Global in the Las Vegas security sector trade fair. After his initial travels to the United States, UC Global obtained a flashy contract, personally managed by David Morales, with the company Las Vegas Sands, which was owned by the tycoon Sheldon Adelson, whose proximity to Donald Trump is public knowledge. At the time, Trump was the presidential candidate. After returning from one of his trips to the United States, David Morales gathered all the workers in the office in Jerez and told us that we have moved up, and from now on, we will be playing in the big league. During a private conversation with David, I asked him what he was referring to when he said we had moved up into the big league. David replied, without going into further detail, that he had switched over to the dark side, referring to cooperating with U.S. authorities. And as a result of that collaboration, the Americans will get us contracts all over the world. In addition to the new contract, after Morales' return from Las Vegas and his comments about the big league and switching to the dark side, I learned through my conversation with David Morales that he had entered into illegal agreements with US authorities to supply them with sensitive information about Mr. Assange and Rafael Correa, given that UC Global was responsible for the embassy's security where Mr. Assange was located. UC Global agrees to send embassy recordings to US intelligence. As a result of the parallel agreement that David Morales has signed with US authorities, Morales commented that these reports would also be sent to the dark side. In order to do this, David Morales began making regular trips to the United States, principally to New York, but also Chicago and Washington. He told me he was traveling to talk with our American friends. At times, when I asked insistently who his American friends were, David Morales replied, US intelligence. 2017, increased embassy surveillance and increasing. From 2017, with the victory of Donald Trump, I realized that David Morales' trips to see the American friends, which he did not want anyone else at the company to take part in, began to escalate. More specifically, around June or July 2017, David Morales began to develop a sophisticated information collection system inside the embassy. He asked the employees who were physically inside the embassy to intensify and deepen their information collection. The employees also received the instruction from David Morales to change the internal and external cameras of the embassy. The interior ones recorded sound. I was also informed by the employees that David Morales instructed a team to regularly travel to London to collect the camera recordings. After this, in Jerez, packages? Oh, in Jerez, wherever that is, packages of information were configured so that David, Jerez, that must be in Spain. Yeah. It's Jerez de la Frontera, or simply Jerez, is a Spanish city and municipality in Andalusia. In Jerez, packages of information were configured so that David Morales would personally bring these to American authorities, with increased details and intrusion on the privacy of Mr. Assange, his lawyers, doctors, and other visitors. He showed at times a real obsession in relation to monitoring and recording the lawyers who met with the guest, Julian Assange, because our American friends were requesting it. Anonymous Witness 2 corroborates UC Global's U.S. ties. This is Witness 2 now saying, I remember that after David Morales had returned from the United States, at a meeting with the rest of the staff, he affirmed that we were moving into the Premier League. After this, I became aware that David Morales was making regular trips to the United States, the context of which my boss, David Morales, repeated to his having gone to the dark side. On 24 January 2017, once Donald Trump had acceded to the presidency of the United States, David Morales sent a message over Telegram in which he wrote, well, I want you to be alert because I am informed that we are being vetted. So everything that is confidential should be encrypted. That's what I'm being told. Everything relates to the UK issue. I'm not worried about it. Just be alert. The people vetting are our friends in the USA. Audio recording of Assange's meetings. In early December 2017, I was instructed by David Morales to travel with a colleague to install the new security cameras. I carried out the installation over the course of several days. I was instructed by Morales not to share information about the specifications of the recording system, and if asked, to deny that the cameras were recording audio. I was told that it was imperative that these instructions be carried out as they came, supposedly from the highest spheres. In fact, I was asked on several occasions by Mr. Assange and the political counselor Maria Eugenia whether the new cameras recorded sound, to which I replied that they did not, as my boss had instructed me to do. Thus, from that moment on, the cameras began to record sound regularly, so every meeting that the asylee held was captured. That's a new word I learned today, folks. I've never read that word before. Asylee, one who is in asylum. Asyllee. Providing recordings to the US. Around June 2017, while I was sourcing providers for the new camera equipment, David Morales instructed that the camera should allow streaming capabilities so that our friends in the United States, as Morales explicitly put it, would be able to gain access to the interior of the embassy in real time. Morales instructed me to place a microphone in the meeting room, placed in the PVC holder of the fire extinguisher in the meeting room, where it was glued to a magnet and then concealed at the base of the PVC plastic. Further to this, David Morales asked me to install another microphone in the toilet at the end of the embassy, a place that had become strategic because Mr. Assange, who suspected that he was the subject of espionage, maintained many of his meetings there in order to preserve confidentiality. David Morales also indicated that the aim was that the surveillance, control of information, and recordings should focus on the meetings of the asylee, especially those in which he was meeting with his lawyers, who were priority targets. So the security personnel that were physically deployed in the embassy were specifically asked to monitor these meetings of Assange with his lawyers, as this was required by our US friends. Dave Morales asked me to steal a nappy of a baby, which, according to the company's security personnel deployed at the embassy, regularly visited Mr. Assange. Morales stated that I had to steal the nappy in order to establish whether the baby was a child of the asylees. On this occasion, Morales expressly stated that the Americans were the ones who wanted to establish paternity, threat to poison or kidnap. I recall that on one occasion, in Jerez de la Frontera, at the UC Global headquarters, around December 2017, David said that the Americans were desperate, that they had even suggested that more extreme measures should be employed against the guest to put an end to the situation of Assange's permanence in the embassy. Specifically, the suggestion that the door of the embassy could be left open, which would allow the argument that this had been an accidental mistake, which would allow persons to enter from outside the embassy and kidnap the asylee. Even the possibility of poisoning Mr. Assange was discussed. All of these suggestions, Morales said, were under consideration during his dealing with contacts in the United States. Obviously, we employees were shocked at these suggestions and commented amongst ourselves that the course that Morales had embarked on was beginning to become dangerous. And that is the update for today. We are up to date currently on the Assange update. So the U.S. strongly considered poisoning Assange. I just want to check the comments. So checking in, people. ECAT, Nan, Deborah. England has really corrupt courts, even more corrupt than ours. I think because they've just been established longer, really. And also because of the monarchy. I didn't even know Amal Clooney was allowed near Assange. My daughter insisted we watch Stranger Things on her subscription, but we never signed on. We're boring. We watch golf. Golf is, I don't even know what to think about golf right now. Well, folks, it's been a slice. Thanks for checking in, Kim. I don't do Netflix anymore. I don't do House of Cards. Oh, you guys really went all out. Oh, Harry Bacharach was in the building. Shout out to Harry for tuning in. I gotta subscribe to him. I met Harry at the Maryland charrette, and we had a great time hanging out. He left, I think, a day before we did. So, but it was fun. He's down with George right now, George Webb and David Underdown, as well as Aaron Adler, Neighborhood News Hour down in Toledo, Ohio. But wow, lots of comments. Thank you for checking in, people. I'm just Bradley Manning deserves to be in Leavenworth, says Tehran Koopa. NSA founder Phil Haney, Obama said, see something, say something. Phil Denton was thrown a shot in the chest a month before his wedding, ruled a suicide. I saw someone saying Assange was compromised. Okay. I recently renewed my Netflix. I mooch off my parents' Netflix, so which I think one of them stopped paying recently, actually. Anyways, thanks for tuning in, people. This has been a game room reading update of the. This guy just said no name, no slogan. James Munder did a show on Assange Spain case today. Might want to check. Yeah, so update coming tomorrow. I'm working on some intros right now for some stuff. So yeah, that's why there hasn't been as much content as usual. Also, I've just been watching the debate and then the Comey. I watched like a lot of the Comey hearing today, which was on earlier. So please give me a like and subscribe. And oh, thanks for that, Martha. Glad you enjoyed the show. And please go hit up my Patreon if you guys are so inclined. Nan is one of my Patreons. Do you think Bradley Manning's sex change is part of op? That is a good question, no name. I think in order, well, it depends what you mean by op. If you think there's an intelligence operation behind Bradley Manning, then maybe. But if it's just Bradley Manning, I would say it's much less likely. But who knows? Maybe Bradley Manning is so dedicated to her ideals that she would do that, such a thing as that, as an independent operation to make herself more sympathetic to the public. I'm not really sure. But was it under Patrius? What do you mean by that, Patrius? Comey, I don't know. Yeah, right. Yeah, Comey, like trying to. He just thinks we're all stupid. Some of us are, but not me, and not. I think a lot of people that are listening right now. So, like, subscribe, check out my brand new tube, censorship free video website competition for YouTube. I'm promoted on there as a Rhodium channel. Hopefully people can go and give me a sub. I'm gonna go on live pretty soon here with Shrimp Zoo for our show. So be on the lookout for that, people. Cheers.